We're living in a time where people are more litigious. And there are others, of course, who wish to have privacy and anonymity, and more still, who wish to establish businesses and need to have a level of credibility and professionalism. Whatever the reason, more and more of our people are using corporate tools and incorporating companies. In this episode of The Legal Brief, we're going to explore these corporate tools and answer the question whether they're more useful than being a nuisance. And to join me in this timely topic is Lakira McSweeney, an associate with Glinton Sweeten and O'Brien. Thank you, Ms. McSweeney, for joining me.
Thank you for having me.
Let's get right into it. First off, explain to us, because we hear it a lot, what is a company?
So a company is a legal entity formed by two or more persons for a common purpose. And that common purpose generally is to engage in business activity and get a profit.
Okay. And are there different types of companies?
Yes. So in the Bahamas, the two main types of companies we have are domestic companies. So these are the companies that are generally incorporated by Bahamians to operate local businesses or hold local assets. The second main type of company we have here in the Bahamas is the International Business Company, the
IBCs.
Correct. And these companies are more so incorporated by foreign nationals who are seeking to do international business from within the Bahamas, or they also use those to conduct local business or hold real estate or such other assets in the Bahamas.
Right. Yes. So those are the two main.
Those are the two main companies.
I've been hearing a lot about nonprofits. Are they also a type of company?
Yes. So nonprofit companies, as its name suggests, are companies that are incorporated for purposes other than to make a profit. So religious activities, charitable purposes, sporting, artistic purposes, and so on and so forth.
Right. So now explain for our listening audience, what is the difference between a company and a trading as?
Okay.
You know, we hear that a lot. Someone's trading as versus a company. First of all, is there a distinction? And if so, what is it?
So there definitely is a distinction. So we know that a company is a legal entity. It is separate and apart from its owners. Whereas a trading as business, also known as a sole proprietorship, this is something or a business that is formed by a single individual. And so he is trading as whatever the name of his business is. So that's the difference.
So that's very important for people to know.
Right.
So in essence, then, when you have a company, that's an entity, or it exists in and of itself.
Correct.
And whereas the trading as is you the person.
You are your business.
You are your business.
Right.
Okay. So is it popular, trading as? Are they popular?
I would say so. I think a lot of persons, it's one of the easier businesses to form. You know, if you wake up today, you have a business plan in mind, you want to go and start a business, you can get your trading as soon as you obtain a business license. Once you've obtained your business license, you've met those requirements, you have a trading as business. Whereas with a company, there's a lot more formalities.
Well, explain that for us. Explain for us what is required. And two, let's take it looking at the Bahamian companies, the limited companies. Explain what do you need in order to incorporate or to start a company?
So in order to incorporate, the first thing you need to do is reserve the name of your company. And there are actually restrictions in Bahamian legislation which speaks to what you can and cannot name your company. Now, it doesn't go into detail and say these are the list of names you cannot use. But for instance, you can't have any offensive connotations in your...
Nothing vulgar.
Correct. You know, you obviously cannot use the name of a company that already exists.
Okay.
And then there are also restrictions on using things like a bank or commerce, because of course those types of names are reserved for persons who are actually doing banking business and licensed by, for instance, the Central Bank of the Bahamas.
So it appears then that as much as possible, they want the name to reflect what you're actually engaged in.
Yes, for
as
the
much
most
as possible.
part. Yes, exactly. And it's also required that you have limited at the end of your company, LTD or limited spelled out.
Okay.
So once you've decided what the name of your company is, you would reserve that. That can be done on the online registry with the Registrar General's Department.
I remember when we used to be able to just phone it in or walk it in, and now, believe it or not,
everything is digitized now.
Is it easier? I don't think you were able to say, but I can say I don't think so. But nonetheless, we have to. People say, "Get with it, Ramona." We got to get with it. Yes. Okay.
So you pay your fee. It's $25, and you reserve that name.
Right.
Once you've decided what you want to name your company, then there's a document that's called the Memorandum of Association that has to be filed with the Registrar General's Department. And this document basically gives you a snapshot of the company. It gives you the name of the company. It will speak to the registered office where the company will be situated, the fact that the company will be limited, liability for its members, so on and so forth.
Right.
That must be executed by two persons. And these two persons are known as the subscribers. And they must take one share each. And so once that is done, that is filed with the Registrar General's Department, along with the articles. These are the constitutive bylaws of the company.
Very important.
Yes. The name reservation, and you pay your government fees. You are able to incorporate a company, I would say, within 3 to 5 business days.
It's quick.
Yes.
Now, we're going to take the break, but once we come back, I want us now to really dwell deeper and talk about, we've already spoken about the subscribers, but now talking about officers, directors, shareholders. Who are they? The distinction, because people get it so confused. You're watching The Legal Brief on ZNES TV 13. I'm your host, Ramona Farquharson.
Next time on Justice with Judge Carroll.
Ms. Bell just moved in about 2 weeks ago, and she has brought 3 dogs, Your Honor. And for the last 4 nights, Your Honor, I was unable to sleep. I am a pilot, and I'm sleep deprived.
First of all, I know he's a bit uncultured, as you can see. I have 3 beagles.
Your dogs don't bother you when they sing and howl at night?
No, it's honestly not that often.
Catch Justice with Judge Carroll, Tuesday, 2 p.m., Wednesday at 8 p.m., right here on the ZNS Network.
We're discussing corporate tools, in particular companies, and whether they are useful, more so than persons would say a nuisance. And just before the break, we were talking about who can incorporate, and we were speaking about subscribers. I want to ask as well, in order to incorporate a company, do you have to have a corporate service provider's license?
So it depends on the type of company you're seeking to incorporate. So for the domestic companies, Bahamian companies, we would call them, you can incorporate your own company.
Right.
You only require a financial and corporate service provider's license if you're seeking to incorporate an international business company.
The IBCs. Okay, so that's good to know.
Yes.
And so now that people know that, you can go ahead and do that. Let's now look at officers. How many officers should a company have? Who can be the officers? Can they be also directors, shareholders? Break it down for us.
So your shareholders of the company, these are the owners of the company. They own the company.
I hope they heard that. The shareholders are the owners of the company. That's so important, because sometimes I think Bahamians, they think something differently, but go ahead.
So the shareholders are the owners of the company. They are the ones who are issued shares. They hold shares in the company. The directors are the managers of the company. They run the operations of the company. They make decisions on behalf of the company for the benefit. It should be for the benefit of the shareholders because they are the owners.
Should be, yes.
Yes. Then you have officers. So these are your president, vice president, secretary, those positions. Those persons, they would be appointed by directors, and they are more so the persons who do the day-to-day. So the directors are not necessarily doing the day-to-day of a company. They're not physically, they don't have to be physically present there. They make decisions through board meetings or written resolutions. So the officers are the ones who are actually involved in the day-to-day operations of the company.
Okay, so that's very good to know the difference. Now, can shareholders also be directors and officers?
There's no legal requirement that states that they cannot be.
Okay.
You know, you're able to be a director, an officer, and a shareholder of the company. So there's nothing that prohibits them from having those roles. I've seen that.
Okay. And so commonly, or what would you recommend, and in knowing the law, you're starting out, you let's say as a family, you wish you carry on a business, you wish to incorporate. What should be, let's say, how many positions should you have and key position in a company?
So at a minimum, for a Bahamian company, you need 2 shareholders at a minimum. Also, there's a minimum number of directors. You need a minimum of 2 directors. There's no specific requirement to have officers, although persons, for the most part, appoint secretaries, to handle administrative work. But there's no minimum requirement for officers.
Okay.
So, but the law requires 2 shareholders and 2 directors.
2 directors. Now, so once we've reserved our name, we've prepared our memorandum and articles of association, and we've put everything in. What else is required in terms of incorporating a company?
So once those documents, and you pay your fees, of course, the fees have been paid, and those are submitted to the Registrar General's Department for their review and consideration, and you've met the requirements of the Act.
Right.
You will be issued a certificate of incorporation. And that document, that certificate will evidence that you have met all of the requirements of the Act and you are officially incorporated in the Bahamas.
And so explain to me as well about the seal, the share book, the strip. I think those things as well you should order as well.
Right. So once you have that certificate of incorporation, well, for instance, if you do choose to go through, let's say, a law firm, these are the things that they will assist with ordering for you, your corporate seal. And this seal is something that is attached to documents that, for instance, contracts that the company is entering into. And that provides some sort of authentication to say that, the company has been authorized to enter into this particular transaction. Yes. And so the seal has the company's name and its registered number.
Yes.
Yes. Share books, which are the share certificates. So we know shareholders hold shares. These certificates will be issued to the shareholders, and it would have the name of the company again and the number of shares that each shareholder holds.
Right. So that's good to know. And of course, the strip is, like you say, usually for law firms.
Right.
And so if the law firm is a registered office or wherever it's registered, you would have that. So if people come in to serve, they see it there. It's usually to the front of the firm.
Yes.
And you'll say, well, okay, I'm in the right place. Here's a strip, and I can leave whatever, serve whatever documentation. So I always say, if you're taking on any legal process, you should have counsel.
Yes.
I certainly believe, particularly when you're getting into the realm of companies, you should make sure that things are done properly. I want to now talk about tenure. How long can directors and officers serve for?
So really and truly, it all depends on what is in the memorandum and articles, your bylaws.
Yes.
Right? Because the Companies Act does not specifically state a particular age. However, directors can serve for as long as they wish, up to the point in which they resign, or they are removed, or they pass away, or they have some mental incapacity. So those are the different areas in which the Act says, you know, these are the reasons why a director can no longer serve in his capacity. But otherwise, he can serve for as long as he wishes.
And can you just, and now we're getting into the hot topics. Can you just remove a director without their knowledge or permission?
So, yes.
Okay. Everybody just sat up. They want to hear this because, you know, in our society, you have so oftentimes, like I say, families of close relatives, friends, they come together, they form a company, and they say, oh, we had a falling out, and they just removed me, and I didn't know.
Yes.
Yes.
So directors may be removed. Again, the Act does not specifically state, you know, like these are the reasons why you would remove a director. But of course, I assume it would be for some misconduct or some other sorts. But a director can be removed by a resolution of either the directors or the shareholders of the company, depends on what the bylaws say.
And that's something that has to be in writing and should, of course, be lodged.
Right. So, yes, each time there's a change in the composition of the board of directors, the Registrar General's Department should be notified by simply filing an updated register.
Right.
Yes.
So that's important for people to know. Right. And whatever vote was taken, almost like a minute.
Right.
And that's something as well that I want us to look at. People, yes, you incorporate a company, and it has an identity of it in and of itself. Right. It's its own, I don't want to say person, but it has its own life.
Right.
Separate and apart from its own, their owners.
Correct.
However, there are certain things that you ought to be doing to make this company really valid, and not that it's just a shell. And what are those things that ought to be happening so that when you look at it, you would say that, okay, this is a proper company or corporate entity being properly run?
Yeah, so the Act requires a number of things. Annual general meetings for the shareholders. The shareholders should be meeting on an annual basis to discuss the company and all things company. And it's at this meeting where the directors are required to lay the financials. At that time, the shareholders should be made aware of how well or how bad the company is doing. You know, for the prior year, as well as an auditor's report. So these are the things that would be laid before the shareholders so they can be aware of what's going on. Because at the end of the day, as a shareholder, you know, you own the company.
You need to know what's happening.
So at that point, they're made aware. And that's why the AGMs are so important and required by law.
Excellent. When we come back from the break, we're going to move further with that because there's so many anomalies and this is just so informative. You're watching.
We have more than anyone else. We are the most. We are news leaders, and credibility is the order of the day.
Why don't you come to the most? Only the Sun can cover you better than our new digital product with exclusive stories and entertaining content.
We are the most. Community TV page and radio community announcements. The most viewers and listeners in the country.
We have the most years of Bahamian history recorded. There's no archive like ours.
I came back home to bring you even more news and local programming. We're simply the most, the news at an S.
Hey everyone, it's your boy Vontae and welcome back to another episode of The Drop. Keep going.
2 minutes to airtime. I came back home to make sure you have the most in news and entertainment. We're simply the most.
And I came back home to make sure that you have the most in information, education, entertainment, and inspiration. We're simply the most. The news at an S, where only the sun covers the Bahamas better.
Welcome back. You're watching The Legal Brief. And in this episode, we're discussing corporate tools, in particular companies, and deciding or helping you to decide whether they are more useful than being considered a nuisance. Miss McSweeney smiles. Some people do feel as if these things get a bit out of their scope or understanding. So we were just discussing about what the requirements to ensure that your company, in particular Bahamian company, is a viable and a true company, not just a shell. But one of the things I want you to touch on is whenever you've incorporated and you go, let's say, to the bank, that's natural to open a bank account. There are numerous requirements. And so just take us through that. What are some of the common things that the banks will request? And in particular, I want you to touch on certificates of incumbency, explaining to people what that is and how they would go about getting that.
Okay. So when opening up a business bank account, the bank would want to see your constitutive documents, all of the documents that make you a company, that shows that you exist here in the Bahamas. So the first thing they'll ask for is a certificate of incorporation, which shows that you exist, you're legally existing here. Another thing they ask for is a certificate of good standing to show that you're paying up with your fees, that you've made all of your relevant filings, and that you are in good standing with all of your requirements under the Companies Act. Another thing they ask for is a certificate of incumbency, And this certificate is usually issued by the registered agent of the company.
Meaning the law firm.
The law firm, yes, the law firm. And it just gives you a snapshot of the entity, the name, the registered office, who are the shareholders, who are the directors, and, those sorts of things, the registered number of the company. And so this provides the bank with just general information that it needs to know. It's a part of their due diligence process with getting an understanding of who owns this company, who operates it,
who's entitled
who can provide us instructions, and probably sometimes they would like a specimen signature of the persons who are going to be on the bank account. So these are the persons who are receiving instructions. These are the persons that can come in and ask us to see information about this account. Yes.
That's very good to know, because oftentimes people, they call in and they don't know, they're in a fluster. Where do I get this? And so that's very good to know. Just sidelining somewhat, we've gone into the companies at depth. Let's look now at how do you start a trading as, practically speaking, how do you do that?
So the first step you would make is applying for a business license with the Department of Inland Revenue. And so you go through that process. I think the current process is you also reserve a trading name, what the name of what you want to operate under.
Yes.
So then after that, you would also submit, I think it's consolidated agency approvals, physical planning, Ministry of Health, Environmental Health Services. And once you submit that application, you've been approved for a business license. I think NIB registration is also involved in that process.
Of course.
Yes. So once you've received a business license, you can then go ahead and start your trading as business.
And I want people to know as well that these corporate tools, they are now required almost in every facet. Let's say if you wish to drive a taxi cab, there are certain requirements for you to be registered. And so persons think, oh, it's only if I'm running a storefront or something large or visible. No, it's not. And so it's very important to know. The cost factor as well, I think it's somewhat less or nominal compared to that of a company.
Yes, especially the process, because the process I've outlined for the business license, it sounds a lot, but it's very simple and straightforward.
It is.
In comparison to incorporating a company and the fees associated. Because in addition to incorporation fees that you're going to pay to your law firm, and the government fees that you're going to pay to incorporate, you also have these ongoing fees. The law firm probably is going to charge you an annual fee to maintain this company.
Ms. McSweeney is certainly referring to herself, to making sure to put that in there.
there will be maintenance fees.
Yes.
Correct. Because you're going to want shareholder resolutions. You're going to want directors' resolutions. You're going to need copies of your
reminders, don't they?
Yes.
They want those reminders. Pick up the phone and call me and tell me.
Free.
Yeah.
So there will be maintenance fees along with your incorporation. And then you have your annual filings. So when we put that aside and we look at starting a trading as business, and the only thing really you have to do is get a business license, pay your business license fees if you even fall under the bracket of paying a business license. You make sure that your NIB is up to date. That's it. There's no annual filings.
In comparison, it's much simpler.
It's much simpler, cost effective.
Yes.
And the ongoing maintenance is minimal.
However, now the flip side of that, and then people need to know now, and that naturally leads us into it, protection.
Correct.
Protection.
So with a company, we started earlier talking about this separate legal personality.
Yeah.
When you incorporate a company, you are incorporating something that is separate from yourself.
It's like giving birth.
Right.
You're creating a person.
It's a person that is separate from you. So it can be sued and sue in its own name. So you can it can hold assets. It can enter into contracts. And so these things are separate from you as the owner. Whereas with a trading as business, any contract you enter into, you're entering into your own name. So you're the person responsible when you're entering into that contract.
Yeah.
Yes, you have a business and a business license, but it's you who are responsible and you're obligated to meet those requirements in your contract.
And people need to know, just bringing it more home to them. Let's say you have a trading as, it's a takeaway, it's a trading as. For whatever reason, there's some bad conk with the crack conk, people become ill. If it's trading as, they come after you personally to pay my medical bills. They're gonna everything. You're gonna be personally served in your name. And however, if you're a company, there's a level of protection. They're gonna go after Joe Blow, Takeaway Limited, and so even though you may be the president or director of that company
or shareholder,
nonetheless, you have a level of protection.
Correct.
And so people need to know the difference.
Yes. And so that's the advantage, the key advantage of incorporating a company. Your personal assets, your personal wealth will not be at stake in the event the company is taken to court or something happens. There's let's say financial difficulties. Forget about the court situation. Maybe you're in debt.
Yes.
It's not the shareholders' personal assets or directors or officers. They are protected from those sorts of things.
So the company that's gone bankrupt,
it's the company.
Can't afford, but not you, the individual.
Correct.
When we come back, we'll look further as to when the corporate veil can perhaps be lifted. Also, I can hear people saying, but Ms. Farquharson, I'm married to someone, and they are putting our house or our assets in a company, and I'm not on it. What rights may I have? So I'm going to throw that little curveball at you when we return. You're watching The Legal Brief on ZNS TV 13. I'm your host, Ramona Farquharson.
A new year brings a new lineup. ZNS is bringing you what you want to watch, so don't blink. What's Trending Lifestyles in the Afternoon starts out the daily programming at 4 p.m. This is followed by Unleashed at 5 p.m., a show that dives headfirst into all topics ranging from headline grabbers to current events. At 6 p.m., Grand Bahamas The Bounce Back graces the airwaves, a review of Grand Bahamas recovery. 6:30 p.m. brings the news from Grand Bahama, and 7 p.m. brings The Big Show, the new Bahamas Tonight, followed by a continuation of news with the Bahamas Tonight Access Now at 7:30 p.m. News with a new twist. Surprise, surprise! At 8 p.m., The Rundown, nightly news analysis for all of the big stories of the day. And wrapping things up at 11 p.m. is the Bahamas Tonight, bringing you fresh news. Only the sun covers the Bahamas better than ZNS.
Welcome back. back. We're having such a very good conversation about companies and sometimes the little sneaky things that people try to do to hide things with these companies. You know, we as a people, we tend to be sometimes very suspicious or cautious when we hear about companies. But the corporate veil, this is a separate entity, a company. When can the court say, okay, granted, it's a separate entity. However, I'm going to lift the veil. I'm going to see the bride. I'm going to see what's really behind this company. I want to know.
Yeah.
When can that occur?
So let's step back for a second. So for our listeners, the corporate veil, it's a company law principle. And it speaks about the separate legal personality, that the shareholders, directors, and officers, they are separate. There is a metaphoric veil in between the company, its directors and officers and shareholders. It's a separation.
Yes.
And so you're asking, in what instances will the court lift that veil? And that means that in which instances would the shareholders, directors, or officers be exposed, personally liable for the actions of the company? And in these instances, it's usually for fraud. When you're seeking to defraud a person, you're dishonest, you've placed assets into a company for the sole purpose of hiding them or defrauding someone, whether in a business transaction, a familial relationship.
There you have it. There you have it.
Or so on and so forth. The court would be looking to see, you know, whether this is reasonable. And in most cases of fraud, they would say it's reasonable. We're going to lift this veil, and you would be possibly held liable personally for the whatever financial difficulties or debt of the company. But the court is very cautious with this because this is separate legal personality is a foundational principle of company law. So it's not at every instance they will lift the veil, but it has to be something serious like fraud to have occurred.
I've also found it, let's say, for instance, where a company says, well, we're going to become insolvent. We're going to just, however, they're leaving employees out in the cold and others, and they're owing these debts even before they declared that we're going to just dissolve. I find that sometimes the courts, if you can persuade them, they'll say, well, okay, let me see really what's happening here. So it all depends, but yes. So it's good to know, for persons to know, all is not lost. Because, let's say, assets have been taken over by a company. It doesn't mean that you can never get a hold of them or access. You can move the courts, and there's certain tests, and the courts will consider, will hear you. So that's very good to know. In recent times, I've found that governments they've made a decision to require churches and other charitable organizations to also be incorporated. And there's been a lot of, I can't say if it's pushback, but questioning as to why are you bothering with the Church of God, God's house, to do this. But now more and more, we have these things called nonprofits. Now, persons, again, would perhaps say, Ms. Farquharson, stop it because the church, I don't know if they would necessarily agree that churches are nonprofits, but nonetheless, they carry on God's work. And so speak to us a bit on the incorporation of these entities, or this entity, nonprofits.
So we spoke about what a nonprofit is. And in terms of their incorporation, there are slight differences because the government, the law looks at nonprofits as something, you know, this is serious business. And so once the name has been reserved and the memorandum of association has been prepared, this actually must be provided to the Attorney General's office. And they have to issue approval for this entity to be incorporated before it then goes back to the Registrar General's department. So that's the slight difference in it. And of course, the time frame in incorporating increases quite a bit because I've seen it takes about maybe 4 to 6 months 6 to 9 months
Yes.
to incorporate a nonprofit
You have to
company.
be calling, it
Yes,
seems.
yes.
And finding out whose desk is this document on in order to get them
It's
to
quite a
pick it up.
tedious process.
It really is. But nonetheless, they say it's necessary. I guess regulations. They want to know. What money the church is bringing in, eh?
So, in terms of incorporations for churches, I believe that majority of churches in the Bahamas, they fall under unincorporated associations.
Okay, go ahead. Tell us about that.
So the way in which they are run, they probably have some bylaws or constitutive documents, some constitution that governs their operations. But if they're not incorporated, there's no specific law that speaks to their operations. So I think this is why there was a push for them to be incorporated as companies, because the law requires certain minimum requirements of you. They require those AGMs and those financials to be presented to the members of the nonprofit.
So you support it?
I have no issue against it.
Yeah.
I'll say that.
Okay.
I have no issue against it.
That's such a legal answer. That's wonderful.
I have no issue against it. I think the Companies Act provides certain minimum requirements. It's how they keep all of us in line, right?
Yeah.
And make sure that it's properly running. Not to say that the churches that are formed on the basis of an unincorporated association, that they're not doing these things. I won't go out and say that they're not having their annual meetings and presenting to its members the financials. Exactly. So once you are incorporated, there's a law that requires you to present these financials. The members of your church or assembly, they should know where their money is going to see how the church is performing, etc. So
I certainly believe, and having been involved in one or two church actions, I find that it has been quite useful, because you would have had, like, as you've indicated, when churches would have commenced or been established, obviously these requirements were not in place. And people, you would find that the leaders were perhaps running the church how they felt it should be run. But now we're looking for more cohesiveness and fairness across the board, where the members can question, particularly if there has to be a change in leadership.
Also,
yes. So
it's an organized process.
Yes.
Yeah.
That, okay, we have to have these meetings, we can vote, this is where it is. It's not someone feeling offended and saying, oh, no.
Exactly.
So it's a good thing.
The Nonprofit Organizations Act of 2019, I think that also assists, because under that act, you don't have to be incorporated. It's unincorporated associations or nonprofit companies, but you have to register. It requires all persons who meet the definition of a nonprofit organization to register. And under that act, you're now required to do certain things. It's required to open a bank account. You need that certificate of registration. So I think the act kind of assists, even in the absence of persons not incorporating.
Yes, it really does. Now, we hear the term, the company's been struck off. Can you explain how does that happen? And if it does happen, what must be done to bring it back into alignment or back on the record?
Okay, so...
Or breathe life back into it.
So once a company has been incorporated, it is added to this official register of companies that have been incorporated in the Bahamas. And if a company is struck off, that means it has been removed from that company register. And the reasons why a company would be struck off, the main reason is non-payment of fees. Non-payment of fees, or you have not been consistent with making your annual filings. So these are the things that you have to upkeep when you have a company. You have to pay your annual fees. You have to file these documents on an annual basis. And I wouldn't say that companies are automatically struck off. You do get a notice, which most persons don't adhere to. But within the notice states a particular period, I believe it's 21 days. And after that,
to
regularize, you will be removed from the register.
And then how do you get back on?
Now, it depends on how long you've been struck off. So if you've been struck off, if your company has been struck off For less than 20 years, you can simply pay the fees. There's a penalty fee, and then you also pay the fees that you've missed for all of those years, and then you will be reinstated to the register. If it's beyond 20 years, if the company has been struck off beyond 20 years, then that's a court application.
So that's good to know. I would say sometimes when we advise clients, we would say, you look at that amount, it may be best to just incorporate something new when you think about however, it's a balancing act, because if there are property debts involved, somehow you're going to have to do it.
And I also want to say, because there's been a recent amendment, I'm not sure a lot of persons know, but when a company has been struck off, what happens is your assets are held by the treasurer of the Bahamas on trust.
Right.
So that's that. After the 20...
persons need to know that your home, your company building,
your real estate, all of that.
So technically, it's not your own, even though you're there.
Correct.
You need to know.
That's what happens when your company is struck off. And then after the 20 years, it actually vests in the treasurer.
Right.
And you will need the Minister of Finance to approve you getting that back. Even if you go ahead and reinstate the company after 20 years, those assets don't automatically go back to you.
So that's very important for persons to know. When we come back, time has just flown by. We're almost done. We're going to look now at some possible amendments or whether or not the Companies Act should be repealed or amended. You're going to give me your view and possible reforms in this area. I know you may be fairly happy with it, but there's always room for improvement. Thanks for watching. You're watching The Legal Brief. We'll be back.
Imagine your favorite dish being cooked right before your eyes. Use your imagination and savor the flavor. Do you smell it? Can you taste it? Hold that thought. We have the right show just for you. Wednesdays at 8:30 p.m. and Fridays at 2 p.m. Dishing it up. Right here on the ZNS Network. Because only the sun covers the Bahamas better.
Welcome back. We're discussing corporate tools, whether they are useful or a nuisance. And time has just flown by. We're in our last segment of this, and there's so much more. I mean, here is the act itself. But before we part, I just want to get your feelings. Are you somewhat happy with the Companies Act, or you feel that it should be repealed?
Definitely not repealed. I'm fairly happy with the Companies Act. Yeah.
Fairly detailed and the amendments that come out.
Yes. So the only thing I would say is back in 2016, the government would have embarked on a digitization process of the registry, right? So that allows for companies to be incorporated online. And so my only thing would be to let's see how we can enhance that, because it's great that we can incorporate companies online, but there's still some things that we have to physically attend the registry for. We still have to physically go there to do company searches and review those files, when it would be great if these can be.
And there's sometimes when the system is down too.
Exactly. So we have.
I don't want to say it, but it becomes a nightmare.
Exactly. So we have the means to order certificates of good standing online, but when the system is down, you have to order that over the counter, which takes weeks, and so when you need those sorts of documents for transactions, and I do a lot of transactional work, so in order to issue our opinion.
And your clients are wanting it. I mean, let's face it, the clients can be so demanding, but which is understandable because things are moving in real time. You want to get that loan. You want to move on let's say, real estate transaction. You can't be held up by this. And they think sometimes you're not doing it.
Exactly.
But, our messengers and our workers would be saying, say it again, Miss McSweeney, because they're the ones over there pushing and fighting to get it. To get it done.
I think we've come a long way in terms of incorporating a company. I still just think we have some more way to go.
I still prefer the old way. I hear you.
You don't?
It was so much faster to me. It really was faster. I mean, but of course they would say just to share numbers. It's not even practical now to do it the old way. I think back then it wasn't as utilized as it is now.
Okay.
But yeah, it was pretty simple. You walked in, get it in a couple of days. They updated the reserving the name, but again, it's understandable.
It just all goes into the ease of doing business.
Yeah.
And persons want to be able to do business from their home, their office. Without actually attending,
towing the line,
registry. Exactly.
And we all know what else has to happen too. If you wanna, I'm gonna leave it alone. I'm gonna leave it alone. But yeah, certainly, I would agree with you. That's certainly an area to be dealt with. Yeah. Anything else?
No, that's it for me.
That's it for you.
That's it for me.
Thank you so much. This episode, as we said, of the Legal Brief, we've gone into discussing corporate tools, in particular companies trading as nonprofits as well, giving you the information, practical steps as well as to how to bring about or how to get a trading as, how to incorporate a company. Also information as to who forms a company. Do you have to have officers? No, the law says 2 directors, subscribers, at least 2 shareholders. All of that useful information, particularly to the end, we found out that if in fact you're not keeping your company valid, then, and it holds assets, real estate, some persons, you have your businesses, your homes and companies, but you haven't updated those companies in years, then guess what? Those assets are vested someplace else, more than likely. And of course, that ought to cause you concern because you're thinking, this is my building, this is my home, and I can leave that, when maybe not. So again, I believe we've imparted sufficient information for you to determine whether corporate tools are in fact more useful than being a nuisance. Ms. McSweeney has made somewhat of a believer of me. I'm leaning towards it's certainly more useful. Yes, there are areas of abuse, but nonetheless, the law, there are avenues for those to be corrected, to be identified and corrected. Thank you for watching The Legal Brief. Join us for our next exciting episode. I'm your host, Ramona Farquharson. Thank you for watching The Legal Brief. Be sure to like, comment, or subscribe for more.